So welcome everyone. My name is Bruce McFarlane. I'm the CEO of BDC Partners. I'm also a director of BDC Law. Today we're doing a seminar on the basics of the franchising code of conduct. And so the reason for doing this is a couple of our clients recently had people that were new starters or in different roles. And so they hadn't had a lot of exposure to the code, to the requirements of the code. So we decided to do this, and which has been, looks like we had a few other people that also wanted to do this as well. So I think we're up to about 50 people that have registered for this. And so if people are watching this later, we are recording this, everyone. So if you do have to drop off for it at whatever reason, we will record it so you can see it, and if any of your colleagues need to see it. So I'll just go to the next slide, Tanya. So just for those of you who haven't been on one of our webinars before, BDC Partners is part of the BDC group. So we've got 4 professional service businesses that we operate. We've also got a tech platform in Hatch, and we've got an investment business where we co-own 4 franchise systems ourselves. But in terms of the professional services, we have the law firm, which we'll talk a bit more about in a sec, BDC Property, BDC Recruitment, BDC Performance are our businesses. And then we're part of what we call the BDC Collective. So people that share our similar values to us work in the franchise and retail industries. So Gap Maps, Fordham's, Benjamin & Benjamin, Associated Projects, and Little Giant Finance are all part of what we call the BDC Collective. And then finally Hatch, which is our lead generation platform. We'll go to the next slide, thank you. So today is the law firm we'll be presenting. So welcome to Jane, Mel and Alexia. So Jane's the managing director of our law firm. Mel's the director, and Lex, or Alexia, but I'll call her Lex because I'll mix that up every time. Sorry, Lex, is the associate director. So welcome, guys.
Thank you.
So we're going to do a bit of, we'll go to the next slide, just in terms of questions. So if you'd like to do, there's a Q&A button, if you can all see that on your screens. If you'd like to ask, if you've got your cameras on, also put your hand up if you want to wave a question. So we're hoping that it's pretty interactive today. I know for a few of the people that I've spoken to about this session, I asked them to do a little bit of homework first. So, you know, it is going to be interactive. I'll go through the next slide, just Tanya. So we've got 6 areas we're going to cover today, which we'll run through, but it can be a little bit fluid. I know, you know, Lex, Mel and Jane have all been working in franchising for a long time, so I'm sure they're open for any questions. And today's a day that there aren't any dumb questions. Like we want people to feel comfortable to ask questions. If you don't want to put your hand up and ask it, put it in the chat and I'll ask it out. But you know, there's lots of people that have worked in franchising for a while, but they just haven't had to deal with the regulatory side of the code. So we might, I've done this session a few times in a face-to-face environment. I've had prizes to hand out. Tanya, you can take the slides off now. Keen to see who's in our virtual room. We're going to ask a couple of questions of the audience. So who's ready for a question? When did the code come in? On an audience participation question. How many years ago? Anyone?
Updated in April this year, Bruce.
That was my next question, Steve. I was going to ask that. Well, the first question is when it first came in. So old people like me in the room, 1997. 1997 was the first time the code came in. Yeah, Steve, that was my next question. When did it last? Well, actually, I'll ask a different question. How many times has it been amended since 1997?
Too many.
62.
Yeah, a lot. A lot of times. Unfortunately, the industry's had a lot of political spotlight shined on it for different reasons, and sometimes because people haven't been doing the right thing, but other times because politicians like to get involved in the business community, and so there's been lots of changes. So yeah, Steve, 1st of April was the last code. A lot of the changes came in then, and then there's some later changes coming in later this year for the code, which is a bit of fun for everyone. So any other questions or anything but comments before we get started on the actual code? Or we might just go straight. So I guess the day-to-day application of the code is something like that with, you know, lots of clients are not sure about. But what sort of things should people in franchise systems be aware of in understanding the code?
So the code It covers some key compliance obligations. So there's disclosure requirements, there's good faith obligations, there's cooling off periods, there's marketing fund use and reporting, which is extending now to specific purpose funds, which we can talk about a little bit later on. It covers dispute resolution, and it covers termination rules and end of term and renewal transparency. So they're kind of some of the key things that the code covers.
So I think it was one of the first industry codes. I think there's a couple of other industry codes now, but so it is actually part of the Competition and Consumer Act. So it is actually law. But in terms of, head office teams for franchise HQ teams, what should they do to stay on top of it? Like, what's the first bit of homework they do?
Yeah, so I think a first point is, as part of induction training to employees who are joining franchisor systems, is to sit them down and get them to watch the ACCC's free course on franchising. So this is a really useful source. It's primarily targeted towards franchisees, but it's equally as relevant for franchisors. And what the ACCC does a pretty good job of is giving easy to digest information about the lifespan of the franchise agreement. So it's a really handy resource. Then moving further, I guess having a think about role-specific workshops. So maybe tailoring some sessions to the needs of different roles. For example, if you've got someone whose job is franchisee recruitment, then they really need to be aware of and on top of the document process. So that covers the disclosure and cooling off time periods and consequences for making representations. In an ideal world, perhaps you might have ongoing training throughout the year, so an annual refresher course, or you could leave it just to when the code is updated, which we know is a frequent occurrence. In terms of resources that would be handy for franchisor systems, perhaps having a code of conduct handbook, so a simplified plain English summary of some of the key elements of the code, and you could include things like checklists for disclosures, renewals, terminations. Obviously, leaning on your legal support is a great way to ensure that you've got clarity and you've got help when interpreting particular sections of the code. And I guess where possible, having checklists and document templates handy. And then ongoing support, that could look like notifying staff of updates to the code, keeping tabs on ACCC, who are really good at putting out blasts for enforcement actions and legal changes, and just having regular reviews of your operations to identify and correct perhaps any non-compliance.
So the code came about to, who's it looking after? What's the purpose of the code?
Well, I suppose it's just to strike the right balance between franchisors and franchisees. I think from the franchisor's perspective, the recent code changes have maybe tipped it a little bit against the franchisors. I think that's probably fair to say. But it's trying to, I guess the fundamental principle is disclosure and transparency and good faith. Yeah,
and good faith. That was what I like to throw questions that are on script for Lex just to keep her on her toes. But the question, good faith, it is to protect both sides. I know Steve's there, like it's not just about, harsh rules for franchisors and to look after franchisees. It's actually there to protect both sides. So, bearing that in mind, both parties have a duty to act in good faith. It's a fundamental obligation of both parties. Just a logistical thing. We've got 5 people, Dom, Kelly, Mark, Natalie, and Tom, that are all in viewer only. So just ideally, if you can just accept, then you can, if you've got a question, and also Kelly, I want to ask you a question. So, we need you to be more to contributors, I think is what the word is. So if you could accept that, that'd be great. So then I guess the process, so the code's got lots of obligations on franchisors, and there's no more obligations than when you're trying to sign up a new franchise email. So the documentation under the code that you need to comply with for a greenfield site, what can you take us through that?
Okay, yeah, sure. So the first step is a standard form information statement that needs to go to franchisees as soon as possible. So as soon as you receive an expression of interest from a franchisee, you need to send that straight back to them, and it has to be provided before the set of franchise documents, which I'll talk about next. So the next set of documents to go out is the franchise document. So that's the franchise agreement, which has to be in the form that it's going to be signed. So some of our clients like to send out a template franchise agreement so they can get some of the negotiations out of the way early. But to start this 14-day consideration period, used to be a disclosure period, it needs to contain all of the details relevant to that specific franchise.
So Mel, if they're sending it out early, if that's often to engage with, say, the lawyer to get some off for the franchisee, is that why they'd send it not in its complete form?
It can be either, depending on the system. Some franchisors like to speak directly to their franchisees, and others might send it to the lawyer just to, I don't know if it streamlines the process so much, but it does mean that once you start this 14-day consideration period, you're more likely to get the documents signed at the end of that period.
Yeah.
So together with the franchise agreement, you need to provide a copy of the current disclosure document and the franchising code of conduct. And then also, if the franchisor is leasing premises that they're going to grant rights to the franchisee, they need to provide a copy of the lease and landlord's disclosure document at that time if they're available. And if they're not, then as much information about the lease as is available at the time.
Cool.
Yeah, so the parties can't sign the franchise agreement until the end of that consideration period.
Cool. And so in terms of a couple of things you mentioned there, the disclosure document is probably one thing that we could touch on a bit more. So the disclosure document needs to be updated annually, and there's a pro forma form of it. What about things like in the disclosure document, people putting in information about the business? Like what sort of information do you often see in a disclosure document that's, that's optional, for example?
Good question. Yeah, so it's got to have all of the standard stuff, which is the terms of the franchise agreement, the costs associated with that sort of thing. It can be used as a bit of a sales document as well, I suppose, with a bit more information. In doing that, though, franchisors have to be really careful that the information they're providing is accurate.
Accurate, yeah. Like information about you need to provide some information about the directors and the business and the key people. So, essentially giving them a lot of information about the people in the business could be that sort of borderline sales type information or compliant information.
Yep. And there were just another couple of documents to mention. Before a franchise agreement can be signed, you need to get an acknowledgement from the franchisee that they've had an opportunity to read the disclosure document and code, and certificates of advice where the franchisees acknowledge that they've been told to get advice from a lawyer, accountant and business advisor, and either the advisor can sign off to say they've provided that advice, the franchisee can say they've obtained that advice, or that they've been told that they ought to and have decided not to.
So that certificate, particularly the legal advice one, there was a bit of debate when the code was changing. Not the last one, I think, Jane, maybe the one before, around whether it should be mandatory. Yeah. Whether it should be mandatory. So what's your view, Mel, on getting legal advice? Is it something that you talk to the clients a bit about?
Yeah, I mean, I started out in franchising, advising franchisees, and there's a lot of stuff in there that people just don't understand, and obviously it's a huge decision. So from a franchisee's perspective, it's really important, but also from the franchisor's perspective, you want to make sure people signing up know what they're in for, and the best way to do that is to have the documents explained to you.
Oh, for sure. I don't know if there's many franchisees on the call, but there's one. Daniel's on the call, so I'm going to put you on the spot. Daniel, if you're paying attention, did you get advice? Is that something that you did as part of your initial process when buying your first Boost juice, if you're not eating your lunch? No, he's not listening. Here we go. So we got a question. Yeah, okay. It's a good question, actually. Is the franchise disclosure document linked to the franchise register?
Can I take that one?
Yeah.
It's not per se linked to the register, but some of the information that you've got in the disclosure document is what you have to put on the disclosure register. And you have an option whether you want to upload your disclosure document and franchise agreement onto the register. In saying that, we have recommended to our clients that they don't, and they complete the information asked and not put any documents. They are confidential documents, so we're of the view that you shouldn't necessarily upload them unless and until you're told that it's mandatory, which it's not at the moment. And whilst we're talking about the register, I just want to mention, and a lot of people don't understand the whole update in the register time frame. You have to update the disclosure register by the 14th day of the 5th month of the end of the financial year. What that means for you, if your financial year is 30th of June, that means 14th of November. By 14th of November, well, you should have updated your disclosure document and then log in and update the information. So you've got 2 weeks after the end date of the update of disclosure document to update the disclosure register, and you all must do it this year. Because I don't know if you've seen in the news, but there's been a couple of cases where a number of franchisors have been done for not updating their annual information.
Thanks, Jane. Daniel, I saw you jumped on. You gone again? There you
Yeah,
are.
sorry, mate. Yeah, sorry, my system had a meltdown.
So, you've got your boost. You're a franchisee. Got your boost. You haven't sold them all. So, what's your view on getting legal advice as a franchisee and signing the certificate?
Yeah, most people need to. I think that's pretty essential. I did the first time around, but they do say that no sane lawyer would tell you to sign it. But I think most people are right. I think Mel said it. It's a really complicated document. You've got to understand the balance of power and what you're really getting into and the synergies of a franchising system. And, so they don't go a bit rogue. But they come in very trusting. There's a bit of a halo in franchising, something we've talked about a lot on the board of the FCA. And just to try and make sure that they see the glowing lights of franchising and think that the franchisor is going to do the job for them. So all of that's pretty important.
Yeah, no, I think that's right. We, often encourage our franchisor clients to encourage their franchisees to get legal advice and to get accounting advice, because we want them to be as informed as possible coming into it. And so whilst you don't have to, that's not mandatory. And you can tick the box to say that you've had the opportunity and you didn't do it. I think it's a good thing that the franchisees do get legal and financial advice before they start.
And Bruce, I just wanted to add that by encouraging franchisees to get legal advice from the franchisor's perspective, that doesn't necessarily mean that the whole franchise agreement is going to become subject to negotiation. Rarely do we kind of see extensive negotiations. Obviously, there might be some things that we get asked and there's a bit of back and forth, but it doesn't necessarily mean that it's going to lead to a protracted process.
Yeah, no, that's right. Obviously, that's a fear that franchisors have, that they're going to end up with all these negotiations and time, and they just want to get the deal done.
I've got to say that there's a couple of franchisors that will actually have it as a mandatory requirement for franchisees to get legal advice and provide the certificate.
Yeah. And so, Mel, one thing that you mentioned about representation, so that's obviously really important. One of the most litigated areas around franchising is, misrepresentation. So, how do franchisors avoid misleading and deceptive conduct in those sort of pre-negotiation stages?
So the most important thing, I think, is to be really proactive about the information that you're providing to franchisees. Make sure it's clear, honest, and accurate. Make sure your disclosure document is up to date, and be really careful with financial forecasts. If earnings information is provided, then it's got to be based on reasonable grounds and ideally using actual data. I just wanted to add also back to the the consideration period, if the franchisor provides earnings information after they've provided the documents, that consideration period is extended to 14 days after they've had the figures. So if you're going to provide them, it's best to provide it with the documents. It's really important not to oversell a franchise opportunity, which it can be tricky. You obviously are trying to sell, but make sure you're not overselling, and avoid giving informal assurances like, oh yeah, mate, for sure you'll earn 300 grand in your first year, because that's where problems arise. Again, encouraging franchisees to get independent advice. You can also include disclaimers and that sort of thing for what they're worth. They do have some value, but it's not, you can't rely on that exclusively to avoid a claim.
Yeah, and the financial information is a hard one. I know we've got a range of different franchise systems on the call today, and obviously ones that are more established have got a lot of data to be able to provide, low, medium, and high ranges for franchisees in terms of financial information. If you're an emerging franchise, it's very difficult, and I know that a lot of law firms will say just don't provide any financials because you just don't have the reasonable basis for providing it. So I think there is striking that balance is a tricky one, but I think, as Mel said, if you are going to provide financial information, you need to make sure that it's accurate and you've done all that you can to make sure it is, because that's the first thing that's going to come back at you in a dispute is a misrepresentation claim. Jane, I'll move to sales and resales. So, are there different obligations if someone's selling an existing site compared to a greenfield's new location?
Yep. So obviously when you have a resale, so a current franchisee selling to the new franchisee, there's a process, and the process is usually documented in your franchise agreement. And, all of our clients have a clause that deals with what happens if they want to sell. In a lot of cases, franchisor will have a right of first refusal for whatever the price and the agreed terms are. And then if the franchisor does not want to buy that particular franchise, they go through a process of approving the incoming franchisee. Franchisor must not act unreasonably in approving the new franchisee, but obviously you want that franchisee to be a proper franchisee for your system and suit your system. Also, you've got to have, and a lot of franchisors don't have the process of vetting the contract of sale between the incoming and the outgoing franchisee. Some systems have a set of special conditions that they provide to all franchisees for when they sell. Some systems actually create a precedent agreement that the franchisees can use as a contract of sale, but it's got to be subject to franchisor's approval, the purchaser signing the franchise agreement, etc., etc. Another thing is there's obviously a separate set of documents. So the new incoming person will get what Mel said. They'll get the franchise pack with the disclosure document, the franchise agreement, etc. But the outgoing franchisee needs to sign, and some systems I have seen don't sign outgoing franchisees on a deed of surrender. And what a deed of surrender does, it sort of ends the relationship properly. It also outlines that what the franchisee has to do on their way out, if they have to pay any fees, for example, a transfer fee under the franchise agreement, and also whether they have to do anything else, pay outstanding fees to you, etc. So that's the only difference. It's a layered approach in terms of resales.
Do you ever see any transfers, Jane, or is it just always the new?
I see a lot of transfers in some of the systems that I'm on their panel for franchisees. Yeah, a lot of sales.
No, but in terms of not a new, the new franchisee just gets an assignment of the existing term, not a new.
No, generally most franchisors give a new term.
Yeah.
But I have seen of late a few systems that will only assign the remainder of the term.
Yep.
Or what some systems do is they will give them a new term, but they make them pay for the extra whatever years that they get on top.
Olga, you got a question?
Yes, sorry. Can you hear me?
Yep.
Yeah.
Yes. You said no dumb questions, so I'm going to ask this. Are there selection criteria for the franchisees? And if they are, what are they?
So
Well, that depends. Yeah. So that depends on each franchisor. And the franchisor should definitely have a proper, not just selection criteria, but, things that the franchisor and the has to do. So not just what they are and who they are, but what they have to do. For example, past training, have certain financial backing, have enough working capital, etc. Do I find my systems match franchise agreement to the lease? Acting for franchisees, it would be the first thing that I would want to ask the franchisor to match the franchise term to the lease. Unfortunately, in a lot of systems, they don't match. But the way a lot of franchise agreements are drafted is they say, for example, it's a 10-year term, but if the lease ends, the term ends. So you've got to be very careful. Well, franchisees have to be very careful in signing documents and understanding what the difference is between the term of the lease and the term of the franchise agreement. And in a lot of those cases, franchisor is on the lease. So franchisee only has a license, which means they don't really have any control over renewal of the lease or negotiations of the lease with the landlord. So they are questions that franchisees should ask before they sign.
Yeah, and it's tricky. I know, Danny, you're obviously with Boost, you're in shopping centres, and so landlords in shopping centres often only grant one term without an option. And so often a franchise agreement will have an option, but there's no lease attached to that because you're sort of both stuck with whatever the landlord's going to do at that time.
One other thing that I'll mention on resales, some franchisors will require, have requirements for their franchisees to do a refurb every, 5, 7, 10 years. And, often in resales, we see that the new person has to do the refurb, but obviously the new person, A, it needs to be in their contract of sale, and B, there's got to be a condition in the franchise agreement that they sign that they have to do a refurb, for example, within 6 months of commencement. And they need to be disclosed all the details about the costs of such refurb, as now under the amended code from 1st of April 2025, franchisors have to have a discussion about the significant capital expenditure.
Cool. And so with resales, it's often you've got, the incoming and outgoing franchisee. Sometimes you've got a landlord. The timeline is really critical to try and get all these parties lined up for a settlement date. And for us, we're often late to the party as well to say, oh yeah, by the way, I've sold, franchisee X has sold to franchisee Y, and it needs to settle in 2 weeks.
Yeah.
What do you recommend in terms of
not to do that is what I would recommend.
Not to do that.
A lot of franchisors have actually set out a time frame and a system where they provide franchisees, when they sell, a time frame of when the settlement can even take place. And in a lot of bigger systems, franchisors are the ones who set the date, not the franchisees. And so in terms of the time frames, you've got to have at least, 15 days, I should say, not 14, for the new person to have the documents, because they can only sign on the 15th day. I also always recommend to franchisors that they need to allow the cooling off period, which is 14 days after the franchisee signs the franchise agreement, to also happen before the commencement of their franchise agreement. And you can have date of agreement today and you can have commencement date in 15 days. So this way, 100% they're not cooling off, they're not getting out, they're starting as a franchisee. So that already is really 30 days minimum. And when I say minimum, if the new franchisee goes and gets legal advice, and then their lawyers start contacting, say if we act for franchise or us, and we have to either make changes or not make changes, but that prolongs the period of 14 days as well. So there needs to be a buffer. And I think sometimes tough love is really good on your franchisees in actually putting your foot down and saying, sorry, you're not going to settle in 14 days. You're going to settle when we tell you to settle. And we're telling you you'll settle in 45 days.
Yeah, it's tricky, isn't it? Because I know
It is.
and even quite a few of our clients are not actively involved in the transfer process. So their franchisees go to a broker, stick the business on the market, and off they go. And so they come back to the franchisee, and obviously they've checked out mentally. They're out. They've sold their business, and the franchisor needs to deal with it. So I think for all the franchisors, I don't know if anyone else wants to comment on the process that they've put in place. You know, David, your system's been around for a long time. I'm sure there's processes in place. I know, Daniel, at Boost, there's lots of processes in place about selling, but I think it's important to, you know, that the franchisors are sort of on the front foot. David?
I think one of the bigger considerations is there's lots of other things to go on as well as the franchise agreement. For a start, they've got to get their banking organised, their FPOS, leases, and a whole host of things. So at various franchisors, Clark Rubber included, we'd have a whole list of processes to work through in a checklist form, so that we would need 45 days notice, for instance, and that is broken down that the ex-franchisee needs to do these, the new outgoing, incoming, and what we need to do. And that would never, ever be deviated from. Otherwise, you end up in trouble. It's that last minute. And it's happened several times, the FPOS isn't ready. So you've got a franchise moving out of a shopping centre or a large retail environment, and they don't have any FPOS available. So they have to use the outgoings, and then there has to be bank transfers, and inevitably there's arguments. So no negotiation. The time is the time. That's it.
So set it out, and that's, as Jane's saying, make sure that as a franchisor, it's not that you're just being difficult. It's just you've got there's a lot of moving parts. What sort of mistakes? No, sorry, Jane.
Sorry, Bruce, but it's also if you actually have a proper policy about how sale happens and you put it in your manual, then no one can question you later.
Yeah.
It's a manual. It's in the manual. It's for all the franchisees. When they sell, you point them to the manual and you say, here's a chapter from the manual on resale. End of story.
Yeah. So what sort of mistakes do you see, Jane, besides an organisational nightmare?
A couple of mistakes. One of the biggest mistakes and probably the easiest to make is when the time frames of when the documents are supposed to be given and when they're not given. You know, the fact that the information statement needs to be given straight away or within 7 days of the franchisee expressing interest in buying your franchise. The fact that, you know, the disclosure period of 14 days, that they have to have it. They can't opt out of it. And I've heard many franchisors ask the question, can we just all sign some paperwork that they can just sign a franchise agreement in a week? No, you can't opt out of it. And I've seen people try. You know, the cooling off period, the discussions
about negotiations in the middle of it, though, because that's the other thing that happens. Deals get done right towards the end. You've done all your documents, you've sent them all out, and then, you know, the vendor and the purchaser do a deal which impacts on the franchisor.
Yes.
And this is where I would recommend that franchisors who are not hands-on in the resales actually become hands-on and control the process of what happens, how the contract happens, the fact that until the contract is in the form that you approve, you're not even going to look at approving the incoming potential franchisee.
Yeah.
So, yeah.
We might keep going because I know I've got more questions about that, because that's a tricky area. But Lex, we're going to now turn to getting rid of franchisees that are doing the wrong thing. So, which is obviously the code deals. There's lots of protections in place, you know, to allow franchisees to have some protection so they can't just be terminated with no real notice. But so what are the common reasons that franchisee agreements are terminated, and what are the common provisions around protection of the parties?
So I guess, yeah, the common reasons that we see franchise agreements terminate, breach of agreement. So where a franchisee fails to meet their obligations, they're late to pay fees, they're not upholding the brand standards, or they're not complying with operational requirements. Another reason could be poor financial performance. So that's part of breach of the agreement, but ongoing underperformance or possibly even insolvency. Loss of trust and relationship breakdown. We see a lot of this. So where there's conflict, poor communication, or a failure to act in good faith, and that relationship between franchisor and franchisee has really become eroded. Failure to comply with legal or regulatory requirements, so non-compliance with workplace laws, health and safety. Reputational damage, so where a franchisee's actions could harm or have harmed the brand. And probably more rarely is just a change of strategic direction. So a franchisor may restructure or exit certain markets. So there's obviously there's obviously terminations that are prefaced on non-compliance or breach or, this relationship eroding. But then there are also terminations that have been negotiated where both parties come to the table, and obviously that they're much easier to handle and a much more straightforward process. And there's both a commercial negotiation there and then a document such as like the deed of surrender to follow. But in terms of trying to prevent terminations for all the other reasons, I guess some of the things to think about in terms of strategies for franchisors. So just thorough recruitment and vetting. So trying to ensure as much as you possibly can that you're selecting franchisees based on capability, values alignment, and financial readiness. Clear and comprehensive training. When things get rough, it's often franchisees who will put their hand up and say, well, you never told me this. I wasn't trained properly.
A lot of finger pointing.
Yeah, exactly. Regular communication. So we've seen franchisees say, well, you don't give me any help. You don't talk to me. Early intervention. So trying to address performance and compliance issues early through whether it's providing additional training, coaching, or giving written warnings before you get to formal breach processes. Support and mentoring. So try to give the franchisees as much support as you can. Regular communication, as I mentioned. So whether it's fostering an open dialogue through site visits. We've seen systems where franchisees say, well, the franchisor, we haven't seen them. We just don't see them. They don't come, they don't check up on us, they don't care. Establishing advisory councils is something that can be really helpful. And just, again, transparent documentation.
So there's obviously there's breaches that are set out in the code, like things that you breach, and then there's obviously breaches that come about through the franchise agreement, things like not selling the right products or, not doing the right thing, wrong equipment, things like that. But either way, there's steps that the franchisor needs to follow before they terminate a franchise agreement, sort of time periods they need to follow, things like that. Run us through some of those steps.
Yeah, so step one, if you're getting to a stage where you've tried to perhaps communicate with the franchisee and that hasn't really worked, and now you want to get a bit more formal, it's to identify the breach and so which actual section of the franchise agreement are they not complying with, and issuing something in writing. So a notice of breach has to be in writing. It needs to clearly outline the nature of the breach, what the franchisee needs to do to remedy that breach, and then you need to provide the franchisee a reasonable time frame to remedy the breach. So typically that's 30 days, but sometimes it's less than. So it's really important to have that set out clearly, and also to allow the franchisee to have a go at trying to fix the mess that they've created. And so it's only in circumstances where they haven't done that. And that's really where the good faith kind of also kicks in. And you get to that 30 days or 14 days or whatever that period may be. And if nothing has been done, then that's when you're in your rights to issue a notice of termination. So those termination timeframes, there are specific circumstances in which you can terminate on an earlier notice. There are special circumstances. So there are things like if the franchisee is convicted of a serious offence, if they're posing a threat to public health and safety. The code enshrines certain breaches that they deem to be, or that they recognise as serious enough to allow franchisors to act sooner than 30 days.
Abandonment is one of those, isn't it?
Abandonment is one of them.
Yeah.
Yeah, insolvency. Yeah. Yeah, that's right.
So yeah, giving them enough time. So I guess, and often the types of breaches, some of them will be things that you can have less time. Obviously, payment of money. You don't, you need to, and often the franchisors and the franchisees are having discussions over a long period of time before a formal breach notice comes out. So they've already had time before they've got the time again. So, but from a franchisor's point of view now, what sort of things should they do to protect themselves for things that would be considered unfair or unlawful terminations?
So keep notes, keep file notes of everything. Follow the code's termination procedures, so what's set out in the code and what's also in your agreements. Act in good faith, so try to engage constructively and reasonably with the franchisee if they're willing to, and document the process. So whether it's issuing a warning and then trying to provide support that then you can later show, especially if you get to dispute resolution process, or you end up in court. So you've got hard evidence to show how the franchisor, what attempts the franchisor has made to help the franchisee. And to that end, a lot of franchisors, even before getting to issuing a formal breach notice, because, it's recognised that things are getting pretty dire at that stage, and a franchisor, it's not a preferred option. Sometimes when there's been ineffectual communication to that point, franchisors will issue what we call a notice of intention to breach. So that's kind of a pre-step to that formal process that I guess shows the franchisee, no, we are getting really serious, and you need to take our warnings and our notices seriously, because we're heading to a stage where it's really going to have quite an impact on you.
Cool. I might jump down to dispute resolution, because obviously they go hand in glove together in terms of terminating, because often when you are threatening to terminate or with a breach, or then actually terminating, the dispute resolution processes in the code come up. And so from a franchisee or a franchisor or a franchisee's point of view, what sort of steps should they take, Jane, in terms of managing a dispute?
Yep. Well, the code does outline quite clearly, the dispute resolution process. But one of the first things, obviously, you have that overarching obligation of acting in good faith. So when there's a dispute, you should try, whether you're a franchisee or a franchisor, generally, in a lot of cases, you see probably more franchisees serve franchisors with notice of dispute, not the other way around. But sort of try to resolve the dispute directly and amicably. So have open communication, clarify what the issues are, what the actual issues are. And always, as Lex said, keep records. You must keep records of any discussions, anything that's verbal, make file notes, just so that you have that sort of continuity of note-taking in where the dispute progresses. Now, the clause 40 of the code actually deals with what you need to do in a dispute scenario if it becomes sort of that formal dispute. So issuing a notice of dispute that needs to talk about, the nature of dispute, what's the outcome that the person seeking, the complainant wants to come out of it, and how to resolve it. Now, the other side who receives the notice of dispute has 21 days to reply and state whether they agree with what's been proposed as a resolution, an action, or if not, the resolution that they propose. Now, quite often, unfortunately, the dispute is not solved at that point. So then the parties have options of mediation, conciliation, and arbitration. Now, arbitration is probably the least used, especially in Australia,
because the way arbitration works, it is any decision of an arbitrator is actually final and binding, whereas mediation and conciliation, it's only binding if people sign terms of settlement. And if it's not resolved at mediation or conciliation, you can move to a court proceeding, which hopefully none of you have to at any point. But it does happen that it goes to a court proceeding. Now, the Australian Small Business and Family Enterprise Ombudsman quite often handles the franchise disputes between franchisors and franchisees, and has a panel of mediators who are very well versed in franchising and know the code. And you probably, if you're doing a mediation, you probably do want a mediator who actually has an idea of what franchising is all about and understands the code as well. Also, failure to participate in mediation or conciliation is a true indication and failure to act in good faith, just FYI. And as I said, legal action is obviously the last step, but that is, if it doesn't get resolved, it comes down to legal action.
So there's lots of different procedures, and a franchisor or a franchisee can institute a dispute resolution process with a notice of dispute. So you end up in mediation, which is often the best result for everyone, to get there with an independent person without a decision being made, which allows you to throw a lot of things on the table, not necessarily providing evidence about particular breaches, but trying to get a resolution. And so it's at that time where, often discussions like, maybe it's time that you exited the system, it'd be a good time to sell, or, there are, or the franchisor might want to buy it back, or there's lots of different things that could be on the table as part of this dispute resolution that's not in the code. And it's not in it. So Jane, with your franchisor, I guess, what sort of advice do you give them in terms of managing disputes before they get to a litigation stage, before they escalate too badly?
Well, it depends how far you are from mediation in terms of managing the dispute. But sometimes all it takes is you retraining the franchisee if it hasn't gone down to termination path. You're retraining the franchisee or having regular check-ins or video calls. Unfortunately, if it gets past that stage, I would recommend you get legal advice. I also would recommend that at mediation you have either a lawyer or a barrister present. And the reason for that is, apart from outlining clearly what your sort of thinking is to the other side without giving too much away and without getting too emotional, because, in these kind of scenarios, people do get emotional. But it's also, if there is some form of settlement agreed to, the parties can sit down, draft the document, sign it there, and it's done. Because I have seen so many mediations where parties have agreed, walked away, changed their mind the next day.
Yeah, what a nightmare. I'm going to jump back. There was a question, anonymous. So, someone.
I like that.
Yes, anonymous. So a franchise system that's not with no lease premises or physical assets, how can abandoned franchisee be legally defined? That's a really good question. So there's no, is it sales activities for a period of time, or, contract of sales or things like that? I actually think that's come up for one of our clients as well, where, a service-based model, and they're just not showing up. They're not washing the dog. They're not, fixing the premises or doing something that they should be doing. Jane, have you come across this?
Well, the thing is, I have come across some of it, but generally franchisees pay fees based on how much they earn. And if all of a sudden there's no fees, they don't earn, means they don't work. So you can, probably in that scenario, I wouldn't necessarily start issuing notice of breach with a view to terminate straight away. I think there needs to be a much longer discussion.
Because abandonment allows you to do it quickly, but often it is, you're right, there's other things that they've breached. If it's a bit tricky to determine abandonment, obviously, it's if they're not returning your calls, they're not, they've got there's no money going through the system. That it looks like abandonment.
And also abandonment is one of the sections that the code changed in April 25, where it's divided the items for termination, which can be part of a dispute by the franchisee, and items that can't be disputed. And franchisee can come back and dispute your breach of for abandonment. So it's probably not worth it in that case.
So we'll do one more topic before we can loop back around to people, because I know that the dispute resolution process is something that most franchise systems unfortunately have to encounter it somewhere along their journey. But just in terms of risk reduction and looking at best practice systems, Mel, how do franchisors best protect themselves to ensure that they're complying with the code?
Yeah, so as we've talked about, there is quite a bit to it from a franchisor's perspective. And it's particularly important now that penalties apply where a franchisor doesn't do certain things that they have to do. So if, depending on the size of your team, ideally having a person or a team dedicated to compliance, obviously not a full-time role, just somebody whose job it is to make sure that these things are happening in accordance with the code. And to help with that, you could have a compliance manual and provide, as like said earlier, training and education to all relevant staff, particularly salespeople and people involved in onboarding franchisees, but also people running the funds and dealing with disputes. You know, there are areas all over the business. To have a standardized onboarding process to make sure each franchisee goes through each step at the time that they need to, and that's all documented, and records are kept for 6 years as required under the code. Conduct audits, and also, as Jane and Lex have both separately said, just document everything. So you need to have really clear documents about any representations made, any training delivered, advice given or declined, when documents are signed, any changes that are made, so that if there are any questions raised, you can refer back to those records. And then I guess overarching all of it is just to try and establish a culture of compliance. It's not just a matter of ticking the boxes, but making it a core part of the business, because it is so important in franchising.
Mel, and I think that's right, is that franchisors that take it seriously and actually, understand it, understand what their obligations are, it makes it a lot easier, because when you get into a tricky situation, such as you want to get rid of someone just because they're the wrong people, every franchise system will make a mistake. They'll recruit the wrong franchisee for their system at some point. So just understanding the steps of getting them in correctly and then the steps of getting them out correctly is really important. So, I think we've talked about the sort of external resources and stuff that we can do. I know lots of people got their cameras off, but there's some large systems on the call. Is there any other questions for people that are, like I said at the start, there's no dumb questions on the call today. So if you've got other things that you've dealt with, Dak, I should pick on you guys at Spud Bar, because we talked about doing this for you guys. Are there any others, Matt or Dak, if you've got any questions that you've come across in the early days, or even Tanya, you've been doing franchising for a little while. Is there things that you've seen, big systems like 7-Eleven and little systems that you didn't really know why that was the case?
Sorry, Bruce, I was just being distracted there. So I'm
I'm just asking you a question
on my computer, which was a bit rude. Look, as far as the code and stuff goes, and I think we've been talking about it all the way through, you want to avoid using your franchise agreement as the whack over the head, because it is about the conversation piece that you need to have with them. So if there are things that you're not up to on the code, I think that's one of the things I have found when I talk to a lot of people that are in franchising, that they themselves, the franchisor, or more importantly, some of their team that deal with franchisees on a day-to-day basis, really don't actually understand what a franchising is and what the code is actually designed for. So I think making sure that your key team that are, face-to-face with franchisees and really understand what, are dealing with them on a daily basis, and more importantly, building those relationships with them, really do have a clear understanding of it. So if you're lucky enough to have someone, on board in your team that's illegal, that use them, and if you don't, then make sure you can have someone that you can chat to and talk to, because most things can get stopped with a conversation if you know what you're talking about and doing it in the right way. But it's often, lack of knowledge on some of the things that get both franchisees and franchisors into trouble.
Nina, I'm not sure if you're there. Thanks, Tanya. I know 2 years ago you were pretty scared about what was going on with the code. You still there? No. So any final questions? Dak, you got any other questions?
Just a quick one, just to jump back to one of the early things that we spoke about. In an internal sale process, and Jane, your comment was around franchisors actually getting involved in that process. To what extent does that actually, or what does that actually look like in terms of getting involved? So the ones that I've seen so far at Spudborough have very much been negotiations and whatnot are held between the two parties, and then they come to us and to formalize it, I guess. But what do you actually mean by that in terms of our involvement in that process?
Okay, so the involvement from the point of view before they finalize the contract of sale, that you vet the contract of sale, and that there's also no misrepresentations in the contract of sale that could come back at you, even though the vendor is making it, the outgoing franchisee. And also that there's requirements, and each system should have their own sort of special conditions that they require in every contract of sale.
Actually, even going back a step, Jane, and is you want this franchisee, whether they're buying a business or a greenfield, you want to approve them. So they need to basically go through your whole process as if it was a brand new site. What sometimes gets caught up is that they're just dealing with the existing franchisee and not you. So you need to be brought in pretty early in that, because whatever your process is to approve them, we need to make sure that they're approved, not just because they've got enough money to buy the business. Tanya, did you have a question or a comment on that?
So it's probably more a comment on that from my 7-Eleven experience. That it really is important that you get involved very early in the piece. And if you haven't actually taken the time, because often what happens and it should happen when you're first recruiting a franchisee, you should also talk to them about when they're going to sell. Even though they're literally just buying it, they need to understand that at some stage they're going to exit this business, and there are rules, there are processes that they need to do. So you need to be ahead of that. The minute they even think of selling, they should actually be talking to you, or they should be aware that they need to talk to you. I think sometimes it gets lost in the noise of everything else, and you end up, as you say, and the challenge you've got is a franchisee, once they've made the decision to sell, they're gone. They're 3/4 out the door anyway. So for you to turn around and say, sorry, I'm not approving that person, creates so many challenges on different levels. So if you can actually get ahead of it first, and it is a case of, if you've got an FAC or if you've got a comms piece, is every now and then just remind people what the rules are in the right way, but just say, hey guys.
Tanya, just in terms of keeping them informed of that process, because a lot of franchise agreements also have an ability for the franchisor to buy it as well. So there's a right of first refusal, or an option even in some franchise agreements, where the franchisor, particularly ones that have got a lot of company-owned stores, might think, well, we'll just buy this one. So David,
I think it's also important to recognise that there's a sliding doors moment happening at the same time as the sale, and that is, at some stage, the outgoing franchisee is out. We don't talk to them anymore. They're gone. But the new one is going to need a lot of support. So you've got to split loyalty between supporting the outgoing, saying, come on, guys, I need this sale. I need it to go through now. And giving the new one time for training, et cetera, et cetera. And at one point, in 6 months' time, you don't want them saying, you didn't support me. That cost me 20 grand.
Well, the other thing is that comes up a lot in terms of price discussions, which is really tricky, because sometimes a franchisor might say, hang on a minute, this person who's buying this business is buying at overs, and we're the ones that are going to be stuck with them, and they paid too much for it. So I'm really conscious of time. Sorry, it's 1:59, and I know we've just got an hour. So Tanya, can you just pull the next slide up just to finish off? But I just, not you, Tanya Robinson.
No, it's confusing to have two Tanyas now in the same team. It's just not happening.
So, firstly, just a couple of things. We will send around a recording of this with an email, just with a couple of tips. So you will get an email from today, which will, so if anyone in your team want to watch it, if you've got any other questions, obviously you can reach out to Jane, to Mel, to Lex, to I about it. Like we said, we're happy to take any dumb questions you like. Just give us a call. We can do that. And so, and I know some of the people on the call, we're going to actually sit down with your team and help with building a process around greenfields and renewals that to assist where should you be involved and where should we be involved in those processes. And lastly, the last slide there, Tanya. So we do have another webinar coming up, which Tanya Robinson and Michael Sutherland from Fordham's. And this is really about what we've just been touching on about resales. It's about, from a franchisor point of view, one is how can we help a franchisee get a really good return on investment? So looking at things that franchisors can do to support their franchisees. And then secondly, a franchisor thinking of selling their business, what should you be doing to get the best return on investment from your point of view, and what sort of things should you be thinking about? So there's a link in the chat there if you want to sign up. Obviously, a lot of you have come through our websites or on our database for our newsletter, so you'll see that in the coming week. I've gone 1 minute over time, so I didn't do my job properly. Thank you very much, everyone, for joining.
Thank you.
Appreciated the discussion, and look forward.
Thanks, Bruce.
Thank you.
Thanks, Bruce.
Thanks.
Bye.
Thanks, Bruce.